I'm going to unmute so people can hear us. Hello, Zoom participants. I'm going to keep the speaker of this device muted for now, but we'll unmute later if you have questions. All right, well, good evening and welcome, everyone. I'm Andy Weisvogel. I'm a member of the First Congregational Church Sanctuary Ministries team, and it's my pleasure to introduce our special guests for this evening on behalf of our church. On May 5th, 2019, following a process of education and discernment, First Congregational Church of Ithaca membership voted to become a sanctuary church, pledging to provide shelter as needed for underdocumented immigrants while their legal cases are in process with the support of the member congregations of the Ithaca Sanctuary Alliance. Specifically, FCCI agreed to educate themselves and the community about immigration-related issues, advocate for justice and immigration reform, and accompany and support immigrants and their families. So tonight's program is in line with the first of those three ideas, the educate portion of our mission. So with so much going on in our world and so many places of concern, we're here to listen to and engage with our distinguished guest speakers around an overview of U.S. immigration policy and learn where we stand right now in 2023. So before I turn things over to our speakers, I just want to alert you to two other talks in the same series that will also be held here at First Congregational. First, on April 16th at 11:30 a.m. After our church service, Ithaca College professor of history, Michael Smith, founder of our Sanctuary Ministries team, will offer a talk on the history of immigration in the U.S., going all the way back. And the final talk in the series will be offered by Cornell Farm Worker Program Director Mary Jo Dudley, who will help us learn more about our many immigrant neighbors in CNY. So be on the lookout for the date and time associated with that. Finally, after our talk tonight, we thought anyone who might be interested, who hasn't already seen our sanctuary apartment, might want to come up and take a look at that and see where our first sanctuary guest was housed and where we hope to host subsequent ones. So now it's my pleasure to turn things over to Oscar Ruiz, who's going to introduce himself and our other speakers for this evening.
Good evening, everyone. Thank you for stopping by and hearing our talk, and thank you to those at home watching. We're going to be covering just what's going on now. So these are just the pipeline. We've got a lot to work through. So just to introduce the speakers, Jackie is the brains behind the operation. She founded the Cornell Immigration Law and Advocacy Clinic, was able to get Cornell to pledge its vast resources in furtherance of this project. So just wanted to know that. And we have Aaliyah Channer. She is an encyclopedia when it comes to immigration policy. She's also a law student at Cornell, member of the Immigration Clinic. Prior to that, she got her master's in international migration and public policy at the London School of Economics. And last and certainly least, I'm Oscar. I am a law student at Cornell Law School, also a member of the Immigration Law and Advocacy Clinic. And I'll bring Jackie just to introduce the clinic.
Thanks, Oscar. Yeah, so just to give you a tiny bit of background on the clinic, what we mean by clinic is that we're basically like a mini law firm inside the law school, just as you would have a medical clinic where you would see patients as a medical student. We work with real clients on their immigration cases. Many of our clients live in Ithaca or in the upstate New York region. We work on cases such as asylum and work with undocumented individuals. We collaborate with the farm worker program mentioned earlier. We work with undocumented students and so much more. And our clinic name is the Immigration Law and Advocacy Clinic because in addition to doing casework and moving the cases forward of individuals, we also have this advocacy piece, which includes things like public outreach to the community and to people who are interested in learning more about immigration, whether that's community members, people who have these kinds of statuses themselves. We give legal updates on cases to stakeholders. And so that's why I'm so pleased that we're here tonight, and the students have really put together quite an amazing presentation for you all. So thank you for inviting. I'll turn it back to you.
All right, so here's the agenda for tonight. First, we are going to be distinguishing asylum, refugee, and undocumented worker status, and then everyone's favorite part, statistics. Please stay away. We're going to be going over some numbers. After that, we're going to discuss how the U.S. is working through Ukrainian asylum claims and asylum claims from Afghanistan. And we're going to take back a step and discuss humanitarian parole visas generally. Then we will move into new carve out for the humanitarian parole visas for Cubans, Nicaraguans, Venezuelans, and Haitians. And then we will touch on Title 42. If you don't know what that is, don't worry, you will walk out of here knowing more than you care to about Title 42. And we will close off with new rule, hot off the press. This is going to come into effect May 11th. So with that, I will pass it to Aaliyah.
Thank you. Good evening, everyone. Thank you so much for having us here today. So like Oscar pointed out, we're going to be overviewing a couple of different statuses here. So you probably heard asylum, refugee, migrant, undocumented, thrown, throughout the media, and they tend to use a lot of these labels interchangeably. So we're going to talk about what each of those statuses are and the protections that they offer folks. I don't know. Is it me?
Yeah, it's yeah.
There you go.
Perfect. Okay. Alrighty. So the first status that we're going to talk about is a refugee. Who is a refugee? So a refugee is someone who has been forced to flee their home because of war, violence, or persecution, often without any warning. So think of somebody who is under threat. They're grabbing their birth certificate, grabbing their passport, grabbing a backpack, and leaving immediately, because that is how much like that present threat is. And they're leaving the country, they're leaving their homeland to seek refuge somewhere else. And they are unable to return home unless and until conditions in their native lands are safe for them again. And this status of refugee is given in that second country that they entered into. And so we'll talk a little bit later about how refugees in second countries can come and be settled into the United States. But next up, we're going to talk about who is an asylum seeker. So an asylum seeker is someone who is seeking international protection, similarly like a refugee, fleeing persecution, fleeing violence. Again, think of somebody on such short notice, grabbing their passport, grabbing their backpack, on the move, ready to go, ready to reach a place of safety, but whose claim for refugee hasn't been determined legally, right? And so an asylum seeker must apply for the status of refugee in their country of destination. And so asylum seekers typically arrive at our borders or a port of entry. So an asylum seeker can come to the US-Mexico border, they can come to the US-Canada border, or once they arrive at any of our airports and say, hey, I would like, that will start the process for them. Next up, we have a migrant. Who is a migrant? A migrant is someone who is moving either within their home country or across borders, usually for economic reasons such as seasonal work or better opportunities. But an asylum seeker and a migrant isn't mutually exclusive. They can be that label can be, upon one person. So let's say an asylum seeker is applying for refugee status and they get denied, they too can still be a migrant because they are looking for, better opportunities, just safety in their life. Because again, they were fleeing persecution, but maybe the United States thought that they did not rise to the legal standard that we would have for somebody who wants refugee status. And lastly, who is undocumented? So those who are undocumented are foreign folks who do not possess a valid visa or other immigration documentations because they entered into the US without documentation stayed longer than their temporary visa permitted. So that could be a student visa, a work visa, or they just otherwise violated the terms under which they were admitted. So here's how folks can go from asylum seeker to the status of refugee. So like I spoke about, in pathway A, refugee. So this is someone who was given the status of refugee in that second country that they entered into. So either by the United Nations High Commissioner of Refugee, they will grant them that status, or perhaps the U.S. consulate in that country can do so as well. And then the United States will agree to resettle them and admit them here in the United States. And that's when we will have a volunteer agency such as the International Rescue Committee or church organizations or any other organizations that will help this newly status refugee resettle in the US. So providing them home, getting them set up with English language classes, just the basic necessities that anyone needs to survive and, live a comfortable life. And the US will support them for about 90 days. And then after that, they're primarily on their own. So the next pathway we have is the affirmative asylum process. And this is essentially folks who are, they could have a visa, they could be undocumented. This pathway B is primarily for folks who are not in removal proceedings. So meaning they are not, the US government does not have a case against them in terms of, expelling them from the country, right? And then when we look at pathway C and D for process for arriving asylum seekers and those in the defensive asylum process, those two pathways can largely be collapsed. Folks in those categories who are applying for asylum, they usually just do not have status. And so they could be in removal proceedings, they just might simply not have a status and are applying for asylum. And so once they request asylum, then they'll go through the process and the judge will adjudicate their claim on whether or not they are granted the status of refugee or not. Okay, so now how can folks go from undocumented to a legal status? And here are just some of the pathways that folks can take. So one of the pathways is being a spouse of a US citizen. So if you are in the country unlawfully due to an expired visa, so your work visa, your student visa, you may qualify for an exception and be able to obtain a legal status. However, if you enter the United States unlawfully, you have to leave the country and spend a good amount of time outside of the US, probably anywhere from 1 year to 10 years before you may be allowed back as a legal immigrant. And the 10-year usually comes in if you have spent more than 1 year unlawfully in the US. But if you spend, I think around maybe 6 to 10 months, you might spend anywhere from 1 to 3 years outside of the US. And
6 months, 3 years.
6 months, 3 years, okay. And so you, and in that category, you have to apply to be allowed to enter back into the United States in your home country. And so next up, another status we have that you can go from undocumented to a legal status is the temporary protected status. And it offers individuals who enter the US lawfully or unlawfully protection from deportation with work authorization, which is incredibly important, allows folks to support themselves while being here in the US. And this status comes into play when there's armed conflict, environmental disaster, and other circumstances preventing folks from returning home safely. And the Department of Homeland Security has designated certain countries that can be afforded this status. So some of those countries are Afghanistan, Ethiopia, Yemen, Honduras, Ukraine, Venezuela. So when we think of these countries, we often see them on the news for one reason or another. Either there's political repression occurring, violence, or any of those reasons. And we can see why the United States would want to extend such protected status to these folks. And additionally, this status only affords people protection for up to 18 months. And after that, you have to return back to your home country.
If you don't mind, the other thing I want to just add about TPS is that it's only for people who were already in the US when the administration designates it. So if you are looking for TPS from Afghanistan, you have to have been in the country at the time that US decided that Afghans need TPS, so if you now arrive, you would not be eligible to get it. So there's lots of countries that have TPS, but it's only like if you've been here from a certain date. For example, like people from El Salvador can have TPS, but they have to have been here since 1996.
And so the next status that you may have heard of, but it's actually not a pathway to lawful permanent resident status or US citizenship, is a deferred action for arrivals, aka DACA. And we do have a DACA expert here, so any questions, please send them her way. And one of another pathway that folks can take again is seeking asylum. So even under TPS, you can still seek asylum as well. And in order to qualify, like we spoke about, there is a high bar. You have to prove that you have been persecuted in the past in your home country due to your race, religion, nationality, and particular social group. But also you have to prove that you reasonably fear future persecution due to these same qualities as well. So now everybody's favorite part, statistics. So we're going to get into just a little bit. Great. Okay, so this graph represents the yearly migrant encounters at the US-Mexico border. And by encounters, we just mean, Customs Border and Protection have encountered people who have crossed the border and are unfortunately expelling them back to the country of which they entered under Title 42, which Oscar will speak about Title 42 in a few slides. And so what we see here is over about 10 years, 4% of migration came from, or 4% of encounters at the US-Mexico border were from countries of Mexico and those in Northern Central America. Now in the year 2022, 43% of encounters at the US-Mexico border were from the countries of Mexico, El Salvador, Guatemala, and Honduras. So when we see that shift, 10 years ago from 4% of encounters from these countries to now 43%, we wonder, well, what caused that change? What caused this increase? And then when we take a deeper look, we see what's happening in these countries, again, going back to violence, political repression, lack of economic opportunity that are promoting people, not promoting, but motivating people to leave, and seek asylum, seek safety, seek opportunities elsewhere. And so in addition to that, oftentimes, the United States may not have an agreement with these countries where they can provide safe return to people in those countries. And so that's a large policy part of it as well, because we don't want to return folks who, if once they return home, they're going to be in grave danger and possibly, may face incredible violence. And so we want to ensure that when we do that, they are there safely. So now we're going to talk a little bit about how the US is adjudicating asylum seekers from Ukraine in comparison to those in Afghanistan. So first thing I want to touch on is when we look at Afghans and Ukrainians, they both have entered the United States through various different channels. So temporary visas, Afghans have SIVs, so special immigrant visas, and also the refugee resettlement program that we spoke about being designated elsewhere and being allowed to resettle in the US. However, most of those from Afghanistan and Ukrainians came under the humanitarian parolee program. And so this allows people to remain in the United States for in the case of 2 years, and apply for work authorization, again, to be able to support themselves here in the US. But looking a little bit closely at the differences between the two, it seems as though maybe the administration might be treating Afghans differently than the Ukrainians differently. And when we think about it, we see that when we look in the case of Afghanistan, the United States was there for 20 years, and we were pulling out, we were primarily responsible for the aftermath that came after that withdrawal. And so the United States perhaps felt a bit of responsibility. And so through the Operation Allies Welcome, we evacuated people from Afghanistan en masse, versus in Ukraine, we weren't a part of that conflict. We didn't start that conflict. We weren't there for 20 years. And in addition, folks in Ukraine had to find their own way to the United States. So they had to buy their own flight, find a sponsor, which is a part of their program as well, and largely do all of that their own. Whereas, like I pointed out, with Operation Ally Welcome for Afghans, the United States sort of held their hand a little bit more relative to the two. In addition, I want to touch on this $575 application fee a little bit. And so those from Afghanistan have to pay that fee to apply to the humanitarian parolee program. However, the median income for those in Afghanistan is $400, right? And so when the United States was evacuating folks en masse, they received approximately $20 million from fees alone in sort of that first round of application from folks, but only about, as of August 22, 0.19% of those parolee applications have been approved. Right, and so, that is just food for thought and just some contextual background when looking at the differences between the two. But again, that goes back to how each circumstance arose, in Ukraine versus in Afghanistan, where we held a hand a little bit more. Ukrainians, they were primarily responsible for getting here on their own. So a little bit of a difference there. And so lastly, I just wanted to plug this really awesome podcast called Inadmissible, asking the question and diving a little bit deeper into are Afghans really being treated differently than Ukrainians. It's really great. They go into it a lot more. And one last bit is that the status of humanitarian parole does allow folks to apply for asylum in the United States. So after that 2 years is up, if their asylum claim is granted, they have an extended stay. And so with that, I will turn it over to Oscar.
All right, so I'm going to take a step back here and just talk about humanitarian parole visas more generally, and just explain the context in which it fits in the overall immigration scheme. So one thing that differentiates humanitarian parole visas from, say, asylum is how quickly a humanitarian parole visa is granted compared to an asylum application. Humanitarian parole, an asylum application can take years. So humanitarian parole visas is there to give the government some flexibility in the event of an emergency. And the status is granted on a case-by-case basis. Okay. So on the graphic, you'll see here humanitarian parole application approved. A more realistic graphic would have said humanitarian parole application denied. These are granted sparingly. Here's the thing, I just want to parse out some of the language here. So those that can apply are those that have a compelling emergency and that there has to be an urgent humanitarian reason or public benefit. So you can think of urgent humanitarian reasons such as civil unrest. The thing is, that term isn't statutorily defined. It means whatever the government decides it means at the time, allowing them to respond to current events. As such, there are different carve-outs to the humanitarian parole program. We'll go over some in a minute, but it doesn't only have to be civil unrest. There are other grounds to be granted in which one could be granted humanitarian parole. Such as a major medical emergency, visiting a dying relative, attending a relative's funeral. Here's another example, donating a kidney to a US citizen. So is that a compelling emergency? Yeah, if you're the one that needs the kidney, it is. And there's an urgent humanitarian reason behind that. I'll give you a hypothetical. How about if a non-citizen needs to attend a civil or criminal court proceeding? Is that compelling? Is there an urgent humanitarian reason at play there? Probably not, but that's why we have the other prong to the rescue. There is a public benefit, especially if the non-citizen is like an expert witness or a witness to the case. So you're starting to see a theme here, dying relative, medical emergency, kidney court case. One of these is not like the other. At any rate, The odds for approval are not good. 75% of humanitarian parole applications are denied. So in response to that, government does set up carve-outs in which different groups of folks get captured into the humanitarian parole program. Some of them are, just to give an example of a few, the Immigrant Military Members and Veterans Initiative, Filipino World War II Veterans Parole Program, International Entrepreneur Parole Program. And just to note, the approval rate varies greatly between the different programs. For example, by the end of June 2022, 17,000 Ukrainians were granted parole status into the US compared to 297 were granted parole. So with that, I bring you the newest of such programs. And you got to give it up to the folks at USIS. They clearly do not have a marketing department. The program is literally called Processes for Cubans, Nicaraguans, Venezuelans, and Haitians. Great. So the new program will admit 30,000 migrants per month. And a little background on this program, this was rolled out last October only for Venezuelans. After this was rolled out, border encounters dropped by 40%. So the idea here is that if there's a legal migration pathway that grants permission before a migrant ends up at the border, it will reduce the amount of border encounters. So another consideration kind of lurking in the background is the not so great diplomatic relations between the US and Cuba and the US and Venezuela. Indeed, when diplomatic relations are frosty, it's just a lot harder to deport folks back to those countries. So let's look at the conditions here. To be eligible for this new program, beneficiaries must meet all 4 of these conditions. So let's work through the first one. Have a supporter in the United States. What does that mean? Can I show up to the border and show them a Facebook message from a US citizen saying, I support you? No, that's not what that condition means. The US supporter has to financially vouch for the sponsee. And they would file a form I-134 to make a declaration of financial support. And what is the point of that? The idea here is to make sure that the beneficiaries have adequate financial support when they get to the US so they don't end up on government welfare programs. Condition number 2, this one's a little more straightforward, undergo and clear robust security vetting. I'm sure the sponsor thinks the beneficiary is great, but the US is still going to conduct their usual background checks before admitting potential parolee under this program. The third prong, meet other eligibility criteria. This is more housekeeping. This includes things like making sure the beneficiary is vaccinated, making sure that the beneficiary passes the required medical requirements. And then condition number 4, warrant a favorable exercise of discretion. This is complete legalese. What this means is that a potential parolee can meet all of the 3 requirements, but that in and of itself does not entitle them to entry. So that warrant a favorable exercise of discretion. It's a matter of administrative grace. Some of the factors considered are the character of the parolee, education, hardship on the parolee in the event of a denial, specialized skills, and things of that nature. So the new program is not without controversy. Take a load of this headline here. You can always count on the free market to monetize altruistic programs. You got folks charging $10,000 to sponsor somebody from Cuba, Venezuela, Haiti, and Nicaragua. $10,000, yikes. And on this other one, you got scammers targeting people hoping to get paroled in. And at least the folks charging $10,000 are presumably filling something out. These guys over here are just taking them for a ride. And last headline here, some states are suing Biden over the new program. What I love about this screenshot here is the little fine print here. Daily average of migrant detentions at border has dropped 40% in January. I think that should be the big headline, but I digress. All right, so now we will go into Title 42. I'm going to give you guys the Ebenezer Scrooge treatment of Title 42, the ghost of Christmas, past, present, and future of Title 42. So with that, oh, big block of text. All right, this is the statutory language of Title 42. I'm going to give everyone about a minute just to work through it before we dive right in. Has it been a minute yet? All right, so as you all can see, this is more so of a public health law than it is an immigration law. And look at the year on this thing, 1944. This is a World War II public health law. And it was initially designed to curb the spread of whatever was killing people then, malaria, tuberculosis. And the reason it's even a thing in the modern era is during the height of COVID, the Trump administration decided to deploy Title 42 as a means to curb the spread of COVID in the US. And that's exactly what happened since 2020. There have been 2.5 million expulsions under Title 42. And keep in mind, this includes migrants who may have otherwise qualified for asylum. It's also worth noting that because it is not an immigration law, it's largely failed to stem irregular migration patterns. And the reason is because there are no penalties if one gets expelled under Title 42. So migrants are incentivized to dust themselves off and try again. So a lot of the numbers you see here are actually attributable to recidivist rates. So Title 42 was arguably a failure of US Customs and Border Patrol, reported an increase in migrant encounters every month for the subsequent 15 months that this was deployed in the COVID era. So a little bit on the politics surrounding Title 42. Biden tried to end Title 42, was sued by a group of 19 states. A district federal judge ruled in favor of the Biden administration. And in a shockingly close Supreme Court decision, the Supreme Court blocked the trial judge's ruling. So Title 42 was here to stay. Trump appointee Justice Gorsuch joined the liberal justices in his dissent, and he notably stated, and I quote, "The current border crisis is not a COVID crisis, and courts should not be in the business of perpetuating administrative edicts designed for one emergency only because elected officials have failed to address a different emergency. We are a court of law, not policymakers of last resort." Bad Congress, bad Congress. So the Supreme Court had it in its calendar to hear the Biden administration arguments on Title 42. This was struck from the calendar, and the reason being is any hearing on Title 42 would have been moot at that point. And here's why. Let's look at some of the language of the Title 42 order. This order will remain in place until either the expiration of the Secretary of Health and Human Services declaration that COVID-19 constitutes a public health emergency, or two, blah, 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 whichever occurs first. So the public health declaration ends on May 11th. So much like the ghost of Christmas future spelled the eventual demise of Ebenezer Scrooge, Title 42 will undergo the same fate, May 11th. So in response to Title 42 being lifted, the Department of Homeland Security and the Department of Justice are issuing a notice of proposed rulemaking. The new rule is meant to address an anticipated surge in migration at the southwest border. The departments expect the proposed rule to lead to a reduction in border encounters, which would lead to a reduction in the reliance by migrants on dangerous human smuggling networks. According to internal government sources, smugglers were expanding their messaging and recruitment efforts using the expected lifting of Title 42 to declare that the border was open. It's not, and trying to induce migrants to spend a lot of money and undergo a lot of risk to take part of the dangerous human smuggling schemes. So without further ado, let's take a look at the new rule, which goes into effect the same day Title 42 gets lifted, May 11th. Drum roll, here it is. Non-citizens who cross the southwest land border without authorization and without having met one of these three conditions would be presumed ineligible for asylum unless they meet certain limited exceptions. Okay, so let's look at condition number 1. Avail themselves of existing lawful processes. What does that mean in English? Well, can you think of some existing lawful processes for, say, Ukrainians? Yeah, well, I was talking about in the previous slide. Or for Venezuelans. So if you are a Venezuelan migrant and you did not pay that enterprising individual from the last like $10,000, you have failed this condition. No, seriously, please don't pay somebody $10,000 to sponsor you. Alternatively, please don't charge somebody $10,000 to sponsor them. After all, you will be able to live them financially. So the approach here is coupling processes for people to enter legally with consequences for those that fail to avail themselves of those lawful processes. The penalties here are stiff. Migrants who fail to take advantage of these programs that are in place are subject to a 5-year bar on re-entry. So if there are any country-specific programs, the rule asks that you seek those out first before showing up at the border. Condition number 2. Presented at a port of entry in compliance with the rules requirements. Okay, well, what are the rules requirements? You have to schedule an appointment through CBP1 app. Yes, the border is taking appointments. Folks, it goes without saying that a government-made app is not going to be the most user-friendly. It's bad. It's riddled with pop-ups, plagued with glitches. The vast majority of people that try to get an appointment on this thing are hung out to dry. I'll give you an example. At a migrant shelter, only 2 out of 240 people were able to secure an appointment through the CBP1 app. You have a recipe for disaster here. Here's the trifecta we're dealing with. We got migrants on their dinosaur phones getting connectivity from God knows what cell tower on the way to the US border, having to make an appointment on this government app. It goes without saying, this is not the Amazon Prime app we're dealing with here. So condition number 2, if you are going to show up at the border, you need an appointment. And again, the idea here is to, for a port of entry to have some sort of predictable flow of people that's consistent with their operational capacity. Okay, so let's say you did not avail yourself of an existing lawful process, and you gave up on trying to make an appointment through the CBP1 app after it froze on you for the umpteenth time. Do I have another option here so that I don't get hit with a 5-year ban on re-entry if I show up to the border? Yes. That's where we get to condition number 3. Been denied asylum in the third country through which they traveled. So if someone did not meet the first 2 conditions, if they go to the border, they have to show that they were denied safe haven while in transit to the US. So those are the 3 conditions, and there are some exceptions. I'll go over just the 3 major exceptions here to the rule. If a non-citizen demonstrates that at the time of entry, they or a family member they traveled with faced an acute medical illness. So there's the medical exception. The other one is if a non-citizen faced an imminent and extreme threat to their life and safety. The key word here is imminent. If a gang member calls me and says they're going to kill me next Thanksgiving, is that imminent? No. So that's kind of a term of art here. And then the third exception is where a victim of a severe form of human trafficking. So severe form of human trafficking is statutorily defined. It means persons in which a commercial sex act is induced by force, fraud, or coercion, or the recruitment or harboring of a person for labor through the use of fraud or coercion for the purpose of subjection to involuntary servitude or slavery. Those are the two exceptions. It's not a catch-all. There's other exceptions like unaccompanied minors. But this is the new rule in a nutshell. This will become law May 11th. And you can already imagine there are some valid asylum claims that will fall through the cracks because of this new rule, even if it's potentially a legal asylum claim or one that would have gotten approved otherwise. So with that, I will open it up for questions. So Jackie can answer them, but you all for spending the evening.
Yeah, this last example I was talking about, it said the third condition was if they can prove that they were denied asylum in the other country they were traveling to. How do they prove it?
They've got to have already gone through the process in that country, say Mexico, and then show that they were.
Right.
It's very difficult, right? Because lots of other countries don't have the same processes that we do, and even if they did have the process that we have, that takes often 2 to 5 years or more. So it would mean basically like having lived in the transit country for some time, having applied for asylum, having been denied it. Realistically, extremely rare.
Could people be helpful in Mexico, say, with setting up a safe place for someone to come and do that? Number 2, you know, trying to get there.
Get on that.
Get on an app. Is that something people do?
Yeah, what's happening in Mexico now is the migrants that are passing through, they are very vulnerable, and the cartels have set up a black market there where they will steal their phones, see if they have any US numbers, hold them for ransom if they do. So it's not safe to just wait around in Mexico as a migrant.
Yeah.
So another thing is the app has 2-tiered authentication. So somebody loses their phone and wants to ask like someone in Mexico to use their phone to log into the app. Well, then to log into the app, it's going to send a text message to that phone they lost, which adds another layer of complexity.
It is really difficult. There are organizations working on the border. Alotro is one of them, and has been working there for quite some time. Sometimes their clinic has collaborated with them, trying to provide services at the border. But as Oscar's saying, it is a pretty volatile situation.
It seems like they're trying to make it as hard as possible as they can.
You know, I
think so absurd, you know?
Yeah, I think that our government is at a point of not knowing what is the best way to actually create an orderly process that will allow deserving people in, not allow non-deserving people, whatever that means, right? Under the law, we've decided who qualifies and who doesn't qualify, but how do we even get people into the process to determine whether they qualify or not? And how absurd is it that sometimes we have people who obviously qualify, like people who came from Afghanistan through Operation Allies Welcome, who a different branch of the government already said, this person needs to be safe somewhere else. Even those people don't just get asylum, they still have to apply. And so you're right, like the levels of processes are really intricate, and I don't think that it's very effective. I don't know what the answer is, but this new sort of set of rules does remind me of Trump's third country transit ban that I was presenting to you probably about in 2018. It's not that different. It's just another iteration in Democrat slogan.
What's the difference between coming into Mexico and coming into Canada? Why is it numbers? Is it?
What's the difference from the government perspective?
Why is it only the southern border that all of this is such a huge problem compared with somebody coming here? Now it's just, there's more population in south than there is north. You know, once you get 100 miles north of the border of Canada, there's nothing.
Yeah, I think there's not too many Canadians that are coming over, but the real reason I think is that it is easier to get a visa, a travel visa from other countries around the world to South America or Central America than it is to Canada. And so what we see is it's not just, I mean, we talked about the statistics a little bit, and it's lots of Mexicans and Central Americans who are coming to the Mexican-US border, but there's also people from all over the world. We might see apprehensions from China and Cameroon and Haiti, right? And that is often because people have been able to secure a visa to Panama or to Brazil. Then they are traveling from those places all the way up on buses and on foot, on trains to get to this border with the US and Mexico. So that's why there's an influx there, and it's not coming from Canada in the same numbers.
But I mean, people don't go, not just Canadians, but people don't get from foreign countries. It's a harder process.
It's harder. Certain communities do. When I was practicing on the West Coast, we saw a lot of Indians coming over in the port of entry in Lake Washington. And so I know the names of all the tiny borders. No, but so we would see like certain communities, certain countries were able to, for whatever reason, get these there. But the other thing is that the US has an agreement with Canada that basically says if you show up in one of these countries first, you have to apply in that country. And so if someone is coming into Canada first, unless they have like a immediate relative in the United States, they're gonna have to apply in Canada first. Anyway, it's kind of the same thing that we're talking about coming through Mexico with this new procedure where we say, you know, you have to have already been denied asylum somewhere else. We already have that agreement with Canada. We think of Canada as having better, more consistent refugee processes, though, and that is the case.
Isn't denying someone the ability to seek asylum at your border a violation of the
Yes. Yes.
and also sending them, not the Geneva Convention, but sending folks back when they have a list of persecution and violence, is also against just human rights, and so people aren't getting credible peer interviews, like, if they have not followed all these procedures.
We don't know yet what it's gonna look like, but I think they're just gonna be turned around. I don't think they're gonna get credible peer interviews because that means that they would have been detained and they're gonna be detained on this side for some time. But I'm not sure yet what that's gonna look like. It's a good question, but yes, I would say that any of our procedures that involve turning people around before they can make a claim for relief and express that fear is a violation of our international obligations and our signing on to the Refugee Convention.
I know it's not exactly your venue or the city procedure, but here about pressure from, for example, dairy farms, for example, in New York State, pressure from them, they need immigrant workers.
Oh, yes, I do hear about this.
Okay.
Yes, yes.
What are the farm owners doing and staying? Who are they pressuring? How's that going?
I don't know, but you should have Rachel Dudley when she
Yeah.
comes. She knows for sure. But I have heard from various folks who want to know, like, how can I hire people? Because I don't have enough workers. Say, okay, my dad works in a hospital, and he's like, okay, I have a vendor who cleans the hospital, but they like can't find people to hire. So he called me and said, just get work permits. I was like, we cannot just get work permits, Dad. But it's not possible, right? Because there's not like a program to give work authorization. And if someone is applying for asylum, they still have to wait 180 days from filing that asylum application to file for work permit, which then still takes another several months. So, and that's if you can turn it in all right away, right? So in any case, what are people doing about it? It's a really big problem that has an obvious solution in terms of giving work authorization to folks who are already here. But I don't see any movement on it, but I don't know what the lobbying looks like right now.
What you're saying is that we can hope that the powers that be will move in some way towards allowing people who are already here to apply for work authorizations instead.
Right, but the problem is that you cannot just apply for work authorization, but you have to have some underlying lawful basis to be here to apply for work authorization. So I don't think anything is going to happen on this, even though we can identify, okay, there's a large undocumented community, say for the farms, for the cleaning company, or whichever kind of organization is trying to hire lots of workers. And there are workers here who want to do the jobs, but they don't have work authorization. So then it's the employer cannot hire them, or they have to look the other way when they're hiring them. And we would want to say, okay, let's just give work authorization to those folks. But if they don't have some underlying, like they need asylum, they have a family petition, they have some lawful reason, we can't just apply for a freestanding work permit. So that's the problem. If we were to somehow make that possible, I think whatever politician made that possible would be seen as like opening floodgates and now everyone is going to come. And instead what we need to do is probably revise our guest worker program to make that possible. But our guest worker visas is first of all a program that's rife with abuse, and also just there's not enough visas. So we have quotas that have it.
I'm not arguing with you, but just trying to figure what maybe could happen someday. For example, if farm owners could say, look, this person has been working with me for the last 5 years, 10 years, could that farm owner then, I know that the answer is no, but I mean, why?
Not right now, but I don't see why. I mean, I think that's a great idea, right? Well, we have other kinds of programs that do eventually, we have one other program I can think of that basically eventually could allow someone to apply for a lawful status in the US after a certain number of years here. It's called cancellation of removal, but it's only available to really certain people. And so the requirements are that you have to have been here for 10 years and that you have to have a qualifying relative who would suffer extremely unusual hardship if you were deported. The qualifying relative has to be a US citizen or permanent resident.
It's going to be your American-born children?
Yes.
Oh, sure.
Yes. So, but here's the catch. You have to show that it would be an exceptional, extremely unusual hardship to your child if you were deported, not just regular old hardship. So it's a high bar. And you also have to ask for this in court. You cannot affirmatively ask for it. So it is super risky. As an advocate, I've never done this. I know some people have, but you have to basically get your client into court to be like, I'm a citizen child with a heart condition and I've been here for more than 10 years. And there's some other requirements too, but anyway, you say you meet them all, but then you have to risk being actually ordered deported because the process involves going before a judge. And unlike some of the other processes, you cannot apply for it affirmatively. So it's really difficult to get, but I agree with you though. I like the idea of like, okay, if you've already established some ties here, why can't we think about that and think about your record as someone who has worked really hard and as whatever other qualifications we,
And maybe
think.
economic pressure to make some of that happen. It is
Maybe,
happening.
yeah.
They're hungry for workers.
And I think we need to get creative about it. Yeah.
Could you talk about the SIDGE visas and how they fit into the current picture? And are they changing or are they still active?
Definitely. So he's referring to special immigrant juvenile status, which is for folks who are children. They have to be under 21, and in some states it's under 18, who have been abused, neglected, or abandoned by one or both of their parents, and to show that it's not in their best interest to return home. So sometimes when we're thinking about farm workers, we actually have lots of youth farm workers here in upstate New York. Many, not all of them are eligible for special immigrant juvenile status, typically because they're usually here without any parent. And so under New York law, we can show that that qualifies as abandonment if your minor child has come to us alone. And so folks, children in this circumstance can apply for this, we call it, when we're talking about it in Spanish, we call it like a youth visa, but this special immigrant juvenile status, it's a visa that you can get while you're already in the US and that leads to lawful permanent residence. So if someone qualifies,
We're both guardians.
so you know all about it. So I would see anything, but for those who don't know already about it, so, okay, so. It's great for, of course, if you qualify for it, and as you know, there's a state court process and there's an immigration process, so it's like weirdly complicated, very complicated, but I have seen that many states have raised the age so that over 18 youth can still qualify, 18 to 21. When I started practicing, it was like nobody did that, then only New York and California did it. Now we see, I don't know how many states, it keeps getting updated, but in the 30s. So that's a change that I've seen that has been good. Oh,
I have a question about 42. Is that an act of Congress, 1944?
yeah.
So then so it's the administration who updates it now?
They've invoked it, so they didn't change it, but they decide to deploy that rule in furtherance of the.
So
for
those
public health
three
emergency.
criteria that we were shown, is that the administration interpreting the law and updating it?
So I'm not sure which criteria it is, but.
For the Venezuelan,
Yeah.
or the new processes.
The next slides?
I think it's the new processes.
Yeah,
Yes,
that's those ones, yeah.
that's administrative rulemaking. So
So does it have the force of law, or is it just?
yes, as a matter of fact, it's still in the comment period. So you can go on the Federal Register, pull up, just really hit the search bar, circumvention of legal pathways.
Yeah.
And you will see the, at, is it Department of Justice and some other, the Department of Homeland Security, the rationale behind it, and they will allow, the public to comment on the rule, throw in their 2 cents, and how can you make it an answer? But it's still in the comments period. So once, those 30 days, this got into the Federal Register February 21st. So in 5 days, the comment period closes.
Okay.
But yeah,
So I have a follow-up then. So because it's an act of Congress, the first law, so Congress could theoretically pass a law and then updates it, and would that supersede what the administration is doing now?
yes, it would, because the Congress can overrule with the administrative.
And then they just have.
But the matter is just to break the gridlock
Yeah.
for Congress to do something. And anything on immigration is just politically toxic.
Right.
It's just, no one wants to do it. It's just easier politically to just maintain the status quo. So they kind of kick the can over to the administrative agencies to work up these rules. Biden is kind of, again, delegating this to the administrative agencies. And really the onus is an anticipated, I don't know the language, but an anticipated surge in migration because of the eventual demise of Title 42. And here's the thing, that's a projected surge. We don't know. I mean, in my opinion, it's an overreaction, but that's the rule they cooked up.
So I guess what I'm really getting at is the complexity in gaining status in the US, could it be streamlined if the Congress simply passed laws? Because part of the reason why it's so complicated is because the administration is doing piecemeal stuff to try to make it work.
Yes, Congress could just pass some laws that would really help a lot right now. For example, we've been asking for the Afghan Adjustment Act for, since 2021. Like, we've had that for other communities, like the Human Adjustment Act. That would just mean, okay, Afghans, like if you're here, we've been there, like, okay, you can stay. But we aren't doing that. And so instead, we have to file thousands of extremely labor-intensive asylum applications. But yes, we could do that. We could change the way that this is, but it would take Congress, and we haven't seen a lot of movement. Yeah.
So this is obviously really complicated. If I'm someone living in not Afghanistan, not Ukraine, a South American country, and and insecure where I'm living and thinking like, if I could get to America with my 2 children, things will be better. What's typical of that person? Do they have any idea how this all works, or is it like, I'm gonna give it a try, I have no idea how to interpret? Be their story.
Yeah, I mean, it's hard to say because on the one hand, like I just want to caveat that there is no like one way that in one story, right? But I think that a lot of times people have a family member or a close friend who's already in the United States. So people are not typically setting out for Mexico and Central America without some connection, some place that they think they're gonna land when they arrive, whether that's their cousin or their parent or whatever. And then people, I don't actually think it's changed a whole lot in the last couple of decades in terms of people are gonna start walking, getting on buses and trains and coming this way. And usually it's at a point of desperation if someone is trying to move in an urgent way like that. If they could avail themselves of lawful processes, people typically want to do that. Why? Because it is incredibly dangerous and fraught and expensive and scary to cross the border. And the people that I have talked to that have done it, it's like unimaginably scary. And so, you know, it's gotta be a desperate situation to be wanting to do that typically. So what does that look like? Usually if they are able to cross, it's probably not at like an authorized place to cross, right? Because if it was, then they would just be told to go back because of Title 42. And so that means usually folks are coming across a river or through a particularly treacherous area out in the desert. And then often actually people are apprehended when they come across, and in fact, kind of hoping to be apprehended because at this point they like maybe haven't eaten or slept in many days. And so I think sometimes, especially people with young children are it's fine to be apprehended. They're like, okay, now at least someone is going to feed me, and then they're put in proceedings though. They can get, even if they can get out of detention and they're not expelled. When we refer to removal proceedings, we mean they have a case in immigration court, and that's widely more popular. I mean, more common, not popular, more common now than when I started practicing 10 years ago, where we saw lots of irregular border crossings without apprehension. That was way more.
Are there still many families who are separated?
There are.
Kids and their parents?
Yeah.
Still separated?
Yeah, actually, I'm co-teaching this clinic with a colleague who works for kids in need of defense, and the project that she is on is the family separation project. So she basically works on a hotline where they are receiving calls mostly for people from Guatemala and El Salvador who are still trying to like reconnect with their kids. In a lot of cases, actually the connection has been made in terms of we now know like where the parents are, and the parents know where their kids are, but most of the kids are still on the US side because they don't want it home, because that's like what they came here, is that it was dangerous there, or that they were starving, or whatever the reason was. Like that still exists in the home country, so the kids are mostly staying here. And then there's a project to use humanitarian parole to bring their parents.
Oh, my God. Do the kids get to decide? I don't want to go back. Like, how are they staying here?
Usually they're with a sponsor. So like I was saying just a moment ago, if people are coming here, they're usually planning to go meet with somebody else they know. And so when people are released from detention, they're released to a sponsor and to an address, not just like randomly. And so the kids are placed with a family member typically. Yeah.
You have to watch this show, The Queen Lady. It's all about this whole thing.
Is it on Netflix?
Pardon?
Is it on Netflix or Hulu?
No, it's on a major network. It's been around for a year. It's a gal that's been trying to, what's it called? The Cleaning Lady.
It's like a thriller.
It's a doctor, but she's a cleaning lady, and she's got a son that's got an illness that needs, help. But it's the whole nonsense of, and the horrible situations and the crime and
Nope.
Question about using data mining and accessing network people. People used to wear ankle monitors, now they have to download an app to their smartphone. I was just wondering if any of you know anything about that. I've heard several articles.
I'm going to delete my CDP one app right now. Thank you for that.
I don't know anything about it. I don't know that it has completely replaced
I don't know.
There is like,
Yeah, repeat what, yeah, can you repeat what you have?
my question,
You know you're getting to.
Kristen was saying that she's read some articles about the CBP-1 app being used for data mining and potentially compromising confidential information of migrants, and what else did you want to say?
There's an app called SmartLink that people are instead of getting an ankle bracelet like you used to get, you have to download SmartLink to your cell phone. And then there have been accusations that everything that's then in your smartphone can be accessed by the government. So they're really developing networks, so like this illegal immigrant is talking to this person and actually they're illegal, and so they get access to these people's networks. And I'm just curious.
I don't know anything specific about it, but it sounds like a ripe area for real challenges. I mean, we see that with lots of different technology as we have over the last decades, right? Like people being denied on discretionary relief because they had like hidden signs on their Facebook page, like accusations like that from social media have certainly been true. Not the same thing, I know, but I think that is an area I'm sure that the government can figure out what to do there.
So when the Mexican consulate comes here, where are they in this process?
Great question. I know. I was just here this summer meeting with them here, yes. That's great when you host them. Yeah, they don't really have a lot to do with it. I mean, you're providing passports for their citizens, right? They are helping people get their birth certificates. Those documents are useful for when someone is trying to go through an immigration process here. And I think that the Mexican government or the Guatemalan consulate is coming to this coming summer, but they are not like involved in whether someone can get status here or not.
So I think about it on documentation.
They
It's
took
like a mobile embassy. It's only.
it's just documents. Yeah, it's like getting people their national ID, their passport.
Shouldn't we also acknowledge the fact that lots of immigrants working here are sending money back home, so the government in Guatemala is very happy about the remittances that are.
Yeah, I mean, remittances are so huge, so I think that, yeah, the government is definitely motivated to come and like sort of do some advocating. Maybe there's some advocating around processes, or at least support for it. If our government's like, okay, if you have this kind of passport, like, we'll look at it. I mean, the Mexican government would probably be cooperative.
I saw something about DACA, that it doesn't give you legal status to stay here.
Yeah.
What, I thought it did. I guess I don't know. Can you tell us a little bit about DACA
Yes.
and what's happening now?
Right, so DACA and TPS are both forms of sort of quasi-legal status. Basically, all they do is say that the government is not going to deport this person for the time period that their quasi status is valid, but they cannot use that to apply for any other long-term relief. So they can apply for their permanent residency from DACA. So just like TPS, DACA is something that has to be renewed on a regular interval by all individuals, and it's like an indefinite just renewal, and all it comes with is work authorization and deferral of removal. So you can't like apply for your family members. The reason that it's different is lots of other statuses do lead to some kind of more benefits, like you could travel outside the country and come back, or you could apply for your family members to come. You can, eventually get citizenship and be able to vote. Like most other longer term statuses come with that, but DACA folks don't have a pathway.
And is there a time limit on it or an age limit, or can it just keep being renewed?
Well, it's a great question.
Okay.
It's 2 years at a time.
Okay.
However, it is only available to this extremely select group of people because President Obama announced it in 2012. And at the time, it had a 5-year look back period. And so it kind of goes to that question that you were saying earlier about like, okay, people have been here long enough. Is that one of the ways you can get them in? That's what Obama did. So since June 2007, you have to have been here among other requirements. We also have to have arrived under 16, under 15, and you have to be 15 to apply. So if you just like do the math on all this right now real quick, there basically like isn't anyone left who could newly become eligible for DACA, because people who are 15 are, were born maybe like in 2006. And so anyway, so it's difficult to, and the parameters have never been extended. So it's the same group of people that at the time that DACA was announced were between 15 and 30, but now it's been 10 years. So now they're between 25 and 40. That's how old DACA recipients are. Nobody younger.
Yeah.
Pretty much.
So it's not really, you can't use it now, really.
Yep.
Okay, so it's.
So I misspoke just now. It's not only 25 to 40. Some people younger than 25, like maybe when they're 20, some people might have it. But 5 years ago, the Trump administration rescinded DACA,
Yeah.
and then there's been a series of lawsuits. Wow, do I have a lot of slides about DACA lawsuits that I won't show you? But there's been so many. So it's like very back and forth. It's been up to the Supreme Court. It's probably going to go there again. Is DACA lawful? Was the program illegal in the first place? Is it illegal to take the program away now that we've already been using it? Like, that's the big questions going on here. And so essentially what we see is DACA is constantly vulnerable, and the people that have it don't have any longer term thing. And so yes, DACA is going to end. And I represent a lot of Cornell students who have DACA, but now it's almost exclusively graduate students. Undergraduates, now they're too young because DACA basically ended for renewals in 2017. So that means those folks are okay.
So what's the law that they argue over in the Supreme Court that DACA comes under? Because DACA is just a policy. Like, what is the?
Yes, DACA is an executive order of non-enforcement.
Right.
And so it's an executive decision to say, we're just not going to enforce the law. The folks that qualify for DACA are undocumented without some other lawful status. Technically, we could deport them, but we just aren't going to do it because we think they tick all of our good immigrant boxes. That's what DACA is. And so what's the law? Well, there isn't any law. In fact, DACA looks really different than a lot of the other immigration laws about like what types of crimes disqualify people. It's like a whole different set of things that was made up by the Obama administration. But in the Supreme Court, then one of the cases that went that far, the question is, did the Obama administration properly put DACA forth under a notice and comment rulemaking that Oscar was just talking about, that this one is under the comment period right now? The Obama administration did not do the comment period. They just didn't do it. And so we have states suing, saying that actually DACA was created unlawfully because it was administrative rulemaking that didn't happen in the notice and comment rulemaking. But before that lawsuit was filed, that was 2016. It's ridiculous, but now basically, but basically, we also had a group of states when Trump said, "I'm going to rescind DACA." It was 2017. He said, "I'm going to end this program, and it's my program because now I'm the executive branch and I can do that." Then we had advocates for DACA come in and say, "No, you cannot. We have 800,000 people who are reliant on this program, and look at all the good things that it's done. And here's our 30 amicus briefs from all the like Fortune 500 companies that have hired DACA recipients. We're going to tell you, you can't rescind it because of reliance interests." And then we saw Texas and several other states say, actually, well, DACA was illegal in the first place. So we had these like barreling two tracks of litigation. Still unresolved.
So people who are no longer young, who had got the DACA state, can they work?
Yeah, they still have DACA, they keep renewing it, and that's DACA exists again. It was basically on like renewals only basis for a couple of years, and now there's a little bit more to it, but yeah. No, they can't get a green card because they have DACA, but DACA is not a path to anything else. So green card is just another word for lawful permanent residency. And so only certain types of statuses have a pathway to that, and DACA is just not one of them.
They're just in limbo, in like a 2-year recovery limbo, where the rug can get pulled from under them at any given point. That's the status.
So I do get to know my my DACA students very well. They're at Cornell for 4 years, maybe they're grad students, they went through for 6 years, I might do their renewal like 3 or 4 times. Cause it's like every 18 months.
And then they would be sent back to a country that they remember, yeah.
So maybe we should do one more question, because then hear from.
Thank you.